In my February 13th, 2024 video, I discussed the status of the right to keep, bear, and wear arms in Tennessee. I reviewed the original language of the Tennessee Constitution from 1796, the amendment in 1835, and the latter in 1870, all of which impaired the natural right of individuals to arms. Indeed, Tennessee's history is indisputable that the purpose of these constitutional provisions was to abrogate that right via Jim Crow laws, which targeted the slave and black population members of the state and ultimately swept us all into the abyss of denial of the right. Let's look at our text and history and talk about the need to have our state's constitution amended again to remove all provisions that are incompatible with the threshold mandate contained in the Second Amendment and its original intent. In 1796, the Second Amendment analog that was contained in the Tennessee Declaration of Rights read thusly: that the free men of this state have a right to keep and to bear arms for their common defense. This closely resembled the actual verbiage of the Second Amendment, but certainly informed the population that ratified it as to the promise to allow the people to keep and bear their arms. It must be noted that the people had just weathered years of war and deprivation at the hands of a tyrannical government, and the frontiersmen, all volunteers, and their families from what would later become Tennessee, sacrificed, bled, and died to wrest liberty from those who would keep it from them. John James Ingalls, a senator from Kansas, said, "Government is force. Politics is a battle for supremacy. We the people are engaged now in that war of politics." Tennessee's 1796 Constitution, Article 10, Section 4 states that the Declaration of Rights hereto annexed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever. And to guard against transgressions of the high powers which we have delegated, we declare that everything in the Bill of Rights contained, and every other right not hereby delegated, is accepted out of the general powers of government, and shall forever remain inviolate. Almost immediately thereafter, the state legislature enacted a law making it a crime for a person to carry a pistol in 1801. Further restrictions were added by the legislature in 1821 and again in 1871, each more onerous than the previous, until 1989, when the present statutes which make it a crime for anyone to carry any firearm with the intent to go armed were passed. The current criminal statutes even makes it a crime to carry a firearm with the intent to go armed in your own home, on your own property, or even at your own place of business. United States Supreme Court cases started to retrench the landscape in the 20th century, starting in 1939 with Miller v. United States, where it was stated that ownership of weapons for efficiency or the preservation of a well-regulated militia unit are specifically protected by the Second Amendment. That is, weapons of war that are suitable for the individual soldier to use or carry are expressly constitutionally protected. In 2008, the United States Supreme Court held in Heller that text and history are the cornerstones for the construction and application of the Second Amendment. At that time, the United States Supreme Court held that individuals have a right to keep and bear handguns for their personal defense. Quoting from that case, putting all these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it shall not be infringed. In Heller, referencing the Tennessee Supreme Court's 1871 decision in Andrews v. State, the United States Supreme Court noted the Tennessee court's holding that a statute that forbade openly carrying a pistol publicly or privately, without regard to time or place or circumstances, violated the state's constitutional provision, which the court equated with the Second Amendment. That was so even though the statute did not restrict the carrying of long guns. In 2010, the Supreme Court of the United States held in its decision in McDonald v. City of Chicago that the Second Amendment, through the Due Process Clause of the 14th Amendment, also applied against the states. Significantly, the effect of the McDonald decision is that the holding has rendered Article 1, Section 26 of our current Tennessee's Declaration of Rights moot and unconstitutional. In 2016, the Supreme Court relied on Heller to conclude that only those arms that were dangerous and unusual would fall outside the protection of the Second Amendment. The most recent and important ruling was authored in 2022 via the New York State Rifle and Pistol Association, Inc. v. Bruin case. Specific and important takeaways from that ruling. Quote, if the last decade of Second Amendment litigation has taught this court anything, it is that federal courts tasked with making such difficult empirical judgments regarding firearms regulation under the banner of intermediate scrutiny often defer to the determination of legislators. But while the judicial deference to legislative interest balancing is understandable and, elsewhere, appropriate, it is not deference that the Constitution demands here. The Second Amendment, quoting from Heller, is the very product of an interest balancing by the people. And it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It is this balance struck by the traditions of the American people that demand our unqualified deference. The test that we set forth in Heller and apply today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. A final word on historical method. Strictly speaking, New York is bound to respect the right to keep and bear arms because of the 14th Amendment, not the Second. Nonetheless, we have made clear that individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government. And we have generally assumed that the scope of the protection applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. The right to arms enumerated in 1791 are natural, and government does not have the power to deny the people their ability to enjoy them. At present, some Tennessee legislators are proposing an amendment to the Tennessee Constitution to address its unconstitutional status. In the House of Representatives, HJR 0038 proposes language for an amendment that follows that text and historical precedent and is necessary. Identically, in the Senate, the companion SJR 0904. Both of these must be passed this year so that they can be placed on the ballot in 2026, which is the earliest possible date at this point that the citizens can vote on the amendment. If you learned information that was beneficial today, tap the like and subscribe button on your screen. It moves our videos up in the algorithms and allows more people to see them. Also, go to our webpage at www.tennesseefirearms.com. Hit the subscribe button on that page to get access to free emails that are there, and they will keep you up to date on issues regarding your Second Amendment rights in Tennessee.